And over the summer, the National Labor Relations Board issued a new decision redefining what it means to be a joint employer under federal labor law.
And what's the new definition?
Well, under this new definition, an employer can be a joint employer, which basically means that you are responsible for the labor and employment liabilities of your business partners. If you simply retain to yourself through, say, your contractual arrangements with your business partner, if you retain to yourself the ability to affect the terms and conditions of that group's employees. So this makes it a whole lot easier to be a joint employer under the law.
And what kind of liabilities do attach?
Well, when you're a joint employer, you're liable for all of the labor and employment liabilities of that business partner. So financial liabilities for wage and hour violations, other employment law violations, potentially even pension and benefit liabilities. And under the NLRB test, an obligation perhaps to sit at the bargaining table with that employer if they have a union.
So if I'm a commercial real estate player, what kind of relationships will this impact?
I think it will affect a number of different relationships. If you're a building management company and you contract with a number of outsourced service providers, you could be a joint employer with them. If you're an investor or an asset manager of a project and you exercise too much involvement in the day-to-day management of that project, you could become a joint employer. If you're a general contractor who too tightly controls the delivery of services by your subcontractors, you could be a joint employer under this test.
And so how do I protect myself?
Well, you have to do two things. First, you have to take a look at your subcontracts with your third-party providers. Are there red flags? Do you have a right in your contracts to control the delivery of services by your contractor in a way that will impact their employees? Identify the red flags in your contracts. The second thing that you have to do is look at the actual relationship on the ground. How are you interacting on a day-to-day basis with your third-party provider? Are you telling your cleaning contractor, I can't have any more overtime this month because you're costing me too much money? Things like that. Once you've identified, performed this legal analysis and identified the risks, then you have to balance any changes that you might make against business reality. There are going to be some relationships where you can make some changes that will minimize your risk of being a joint employer, and there are others where you may conclude that you just can't. It's a balance of legal risk versus business reality. I'm in negotiations with 32BJ in New York City right now for a new building services contract. So for one of those outsourced service providers that we were just discussing. If the NLRB had its way, the building owners might be required to come to the bargaining table with us. The NLRB is not the only federal agency that's rewriting the joint employer rules. The Department of Labor recently issued an expanded definition. The EEOC is pushing to expand its definition, and the Occupational Safety and Health Administration is also pushing to expand the definition of joint employment. All of these things are going to open employers up to greater liability in the labor and employment space. One trend that sticks out to me is the rise in flexible working arrangements. We've seen across all different industries. If your employees are working at night, catching up on emails, doing things like that, should you be paying them for that? Do you have a policy that addresses flexible work arrangements, and are you enforcing it consistently? I think you're going to see a lot more litigation going forward in the area of flexible working arrangements.